the Honorable Chief Judge of Lagos State, the distinguished and Honorable Attorney General of Lagos State, learned senior advocates of Nigeria in attendance, distinguished colleagues, ladies and gentlemen. This is the Lagos Justice Summit. It's been hosted by the Ministry of Justice, Lagos State, the Commercial and Regulatory and Investment Disputes Best Practices, CRID-LawNet, as well as the Justice Reform Project, JRP. And the purpose of this workshop is to familiarize ladies and gentlemen who are attending with the distant remote hearing practice directions recently enacted into a practice direction by my Lord, the Honorable Chief Judge of Lagos State, to be applicable to urgent, time-bound, essential cases that have been filed or that may be filed during the period of the COVID pandemic. My Lord, the Honorable CJ of Lagos State Public Practice Directions on the 4th of May, 2020. And we thought, the Ministry of Justice, CRID-LawNet, and JRP thought that it was important to provide a platform to discuss the way forward during the COVID pandemic and after the COVID pandemic. Thanks to the efforts of the Honorable CJ, we have a set of rules to guide the hearing of urgent, essential, and time-bound cases. However, on the most optimistic prediction, the one that I last saw on international media, the earliest time that a vaccine is likely to be available is anywhere between 12 to 18 months, and that pretty much takes us into the first quarter of 2021. All over the world, courts of different jurisdictions are examining how to reopen for normal business. The remote hearing practice directions are a very good first step. This workshop will be looking at those remote hearing practice directions. We'll also be looking at what opportunities there are to scale up the application of virtual hearing technology to other matters aside from urgent, time-bound, and essential cases. In effect, the normal business of the court. And to discuss this subject today, we have a distinguished group of panelists, and I will introduce each one of them one by one. My Lord, the Honorable Chief Judge of Lagos State, who has joined us, will be presenting very briefly for 10 minutes the Lagos State practice directions on remote hearing of cases during the COVID-19 pandemic. We will then hear from my Lord, the Honorable Justice Hakeem Oshodi of the High Court of Lagos State on what the prospects are for restoring full service in justice delivery, scaling up the use of virtual hearing technology. We will then listen to Mr. Dan Wilmot, who works with the law firm of Stewarts in the United Kingdom and has just concluded, he and his partners have just concluded a case in the commercial court in England that was commenced and concluded exclusively using remote hearing technology. We will hear from Professor Oshikwiton, Senior Advocate of Nigeria, and Mrs. Funke Agbo, Senior Advocate of Nigeria, on what evidential problems could arise when we try to use virtual hearing technology to conduct actual trials. That's matters in which you have to call witnesses. Then we will hear from Mr. Shuko Shashore and Mrs. Mianaya Essien on what possible constitutional issues could arise when using remote hearing technology. Before I call upon this distinguished panel of speakers, the organizations that have provided a platform for this workshop will present just for 3 minutes each, through their representatives and their leaders, an introduction to the organizations themselves and their mission. Starting with the Honorable Attorney General of Lagos State, Mr. Muyo Onigbanjo, SAN, and then we will hear from Mrs. Toki Mabugunje, the President of the Lagos Chamber of Commerce, which is the mother body of CRID-LawNet. We will hear from the President of CRID-LawNet himself, Mr. Tayo Oyetibo, Senior Advocate of Nigeria, and we will then hear from Mr. Shubo Shashore, who represents Senior Advocate of Nigeria, who represents the Justice Reform Project. So before I hand over to you, Honorable Attorney General, I will quickly adjust my tie. I have been at home for so long, I've almost forgotten how to knot a tie. So please forgive me. So Honorable Attorney General, over to you. Thank you very much, sir.
Thank you very much, Leonard Senior Advocate. It gives me great pleasure to be addressing all our distinguished colleagues this morning. I see that we have on board the Honorable Chief Judge of Lagos State, Mr. Justice Kazeem Alugba. I also recognize the presence of a very distinguished predecessor in office, Mr. Olashupo Shashore, SAN. May I then stand on the protocols as established by Tunde? At the Lagos State Ministry of Justice, we recognize the times that we are in, and we feel that it is incumbent upon us as the vanguards standing standing at the doorway to the administration of justice to ensure that this pandemic does not ground or paralyze the administration of justice. As a result, we entered into consultations and discussions with the Honorable Chief Judge about issuing a practice direction which will address or permit our colleagues to go to work with their safety being paramount. Indeed, there's no doubt that we stand on the verge of history, as history will record us as having, at this stage, virtually done something which hitherto in Nigeria had not been done. The first practice directions in Nigeria, to my knowledge, dealing with remote sittings of court is the one issued by my Lord the CJ on the 4th of May, 2020. There's no doubt in our mind that it is an idea whose time has come, and it's going forward. I believe that it's going to be the perhaps only platform available for us to practice law safely until the vaccine is discovered to treat the COVID-19. So our role in the Ministry of Justice really is to ensure that everything continues to work and that lawyers and all the end users of the justice system do so in a safe atmosphere. I haven't said this much. It is my pleasure to welcome you all and indeed to wish each and every one of us very, very fruitful deliberations this afternoon. Thank you very much.
Thank you very much, Honorable Attorney General. Mrs. Toki Mabugunje, the President of the Lagos Chamber of Commerce, the floor is yours.
Thank you very much, sir. The Chief Judge of Lagos State, Honorable Mr. Justice Kazeem Alugba, the Attorney General of Lagos State, Mr. Oyeshore Onigbanjo, SAN, Mr. Shubo Shashore, SAN, of the Justice Sectors, Mr. Babatunde Fagundu, SAN, distinguished panelists and speakers, distinguished ladies and gentlemen. On behalf of the Lagos Chamber of Commerce and Industry, LCCI, I join Lagos State, CRID-LawNet, and the Justice Reform Project in welcoming you all to this virtual workshop with the theme, Making Virtual Hearings Work. We're honored by the presence of the eminent personalities from the bench and the bar at this virtual workshop. and we thank you sincerely for honoring this invitation. The Lagos Chamber of Commerce International Arbitration Center, known as LASEAC, is an independent full-service alternative dispute resolution center that's affiliated with the LCCI. LASEAC focuses on the provision of tailored dispute management solutions, assisting businesses not only in their resolutions, but in the management of disputes. LASEAC aims to provide a viable and user-friendly alternative to traditional litigation, offering a full service of ADR solutions, including arbitration, mediation, and conciliation. CRID-LawNet, on the other hand, is a project of the Lagos Chamber of Commerce and Industry, LCCI, and it's an advocacy group whose primary focus is to promote best practice across all functions which impact justice delivery in commercial disputes. LASEAC is quite involved in the rollout of this project, and the mission of CRID-LawNet is to transform the culture of commercial dispute resolutions in a positive way by engaging stakeholders through programs and activities in order to reform laws, develop institutions, and build human capacity that will support the effective dispute resolution. To this end, CRID-LawNet collaborates with state, judicial, and legislative bodies, as well as branches of the NBA on specific activities. At the LCCI, we are quite pleased that LASEAC is in the vanguard of deepening the awareness and knowledge of the value of digital applications to the operations and processes in our judicial service delivery system. The use of technology in our processes and interactions is now the new normal. The COVID-19 pandemic, having caused several disruptions to various spheres of our national lives, is causing us to transform our judicial systems. A positive outcome of this pandemic has been the amazing traction that the use of digital platforms has gained in the last 2 months. Even the most conservative institutions are now embracing the use of digital platforms for their engagements, operations, and processes. And our judiciary is not an exception to adoption of this new normal. I believe there's tremendous value to be gained from this transition. The LCCI will continue to commit and provide all of the necessary support for the advancements of the work of LASEAC and CRID-LawNet. And once again, I thank you all for honoring this invitation. I look forward to an exciting and enriching session. Thank you for attention. Thank you, Chair.
Thank you very much, Madam President. We are 6 minutes behind time. I would hand over the floor to President CRID-LawNet, Mr. Tayo Itibo, SAN. Please, if you can accomplish this in 2 minutes, I'd be very grateful. Thank you very much.
Yeah, thank you, Tunde. I greet my Lord, the Chief Judge, and the Attorney General, and all participants. As we've all been told, this workshop has been put together by CRID-LawNet. CRID-LawNet is a non-governmental advocacy group. We committed to the promotion of best practices in the resolution of commercial disputes. Membership of the body is open to corporate organizations, including lawyers and individuals. CRID-LawNet is committed to a number of projects aimed at advancing best practices in the resolution of commercial disputes. And the flagship of this progress is the Administration of Civil Justice Bill. The bill has been introduced to a number of states of the Federation, but in particular, the state has, however, taken the lead by enacting the bill into law in the year 2019. The Federal Attorney General is also currently taking a look at the bill, and we are hopeful that it will very soon be introduced at the National Assembly. We're also looking forward to Lagos State adopting and enacting the bill into law. So if I may give the notice, very soon we will be knocking on the door of my Lord, the Chief Judge, as well as the Attorney General of Lagos State, to have their input into this bill, with a view to introducing it at the State House of Assembly. Today we have quite a number of cerebral speakers, and I'm sure at the end of the workshop, we will be glad to go that we have attended this workshop and have learned a lot as to how we can make virtual hearings work. Thank you. As we commence.
Thank you very much, Mr. Etibo. And then I will now hand over to Mr. Shashore to introduce the Justice Reform Project. Mr. Shashore, SAN, the floor is yours.
Thank you very much. Good morning. My Lord, the Chief Judge, Learned Senior Advocate of Nigeria, the Honorable Attorney General of Lagos State, ladies and gentlemen, it's a pleasure for me to represent the Justice Reform Project. My name is Olashpo Shashore. I'm a partner in ALP. JRP is a company limited by guarantee. Therefore, it is a registered not-for-profit. Its main objectives are to promote the advancement of the justice sector. We are specifically dedicated to ensuring that data, information, and other related materials are available to the justice sector, because we believe that that is an important tool for innovation and reform. We think that the state of our justice sector in Nigeria and many parts of it individually require critical looking at this stage, and we offer ourselves to be a vehicle for that improvement. So we want to improve access to justice and ensure that other reforms and other like-minded organizations collaborate with us in doing so. JRP is a coalition of Nigerians from across the legal profession, civil society, academia, and the general public at large, because we believe that we are all stakeholders in the justice sector. And the mission of reform and renewal is something that should be dear to every citizen in Nigeria. And we have several watchdog functions, and we are committed to making sure that our interventions in the sector are both purposeful and engaging. Some of our tools for intervention, I think it's important to mention, involve engagement and dialogue, events such as this, investigation where necessary, online public complaints and the whistleblower platforms, our petitioning method in order to advocate for change. Certain areas that require transparency we think must be exposed. We will engage in public interest litigation where necessary, and training. JRP is particularly delighted, on a final note, to be part of this, because this measure introduced by my Lord, the Honorable Chief Judge, and the innovative Lagos State generally, is one of both innovation and technology. And we think these are veritable tools for reform. So we are delighted to be part of this conversation, and we hope we can make useful contributions to making sure that this is an ultimate success. Thank you.
Thank you very much, Mr. Shashore, SAN. So the stage is now set for the plenary session of this virtual workshop, and it will be flagged off by my Lord, the Honorable Chief Judge of Lagos State, Honorable Mr. Justice Kazim Aloba. My Lord, congratulations on the issuance of the Lagos State Practice Directions on remote hearing of cases during the COVID-19 pandemic. I will now hand over the floor to you, sir, to introduce the directions to the audience and basically give us your perspectives on how you think we can now move forward from the urgent time-bound cases to opening up the business of the courts a little more. I give you the floor, my Lord, sir. My Lord, I think your phone is still on mute. I think you will have to take your phone off mute to be able to, for us to be able to hear you, sir.
Hello? Hello?
Yes, we can hear your voice, my Lord.
Thank you very much.
Alternatively, I'm not sure if the administrator can. Right. My Lord, you're on air now. Thank you very much, sir.
Hello? Thank you very much. Well, I also extend all courses earlier extended just to save time, but I may not begin without mentioning the fact which I observed that Tayo's fundamental right was breached when you cut 1 minute from his own time. But when it came to the time of Shashore, you allowed him to speak fully. I don't think this has to do with height, but it is one of the things we may be dealing with during virtual hearings. So we may note it for now.
Thank you, my Lord, for speaking for me.
Thank you very much. I welcome. Thank you very much. I will not accept any fee for the brief. I thank everybody
Very well.
for this gathering. And it only shows that we are not oblivious of the times we are in now. And as human beings, we are rising up to the occasion, because that is where and how God has made us be better than animals. We are all aware of what led to these practice directions and the need to resort to remote hearings. I do not need to go back on all that. But let me clearly say that the Attorney General, although he's not an economist, was a bit economic with the full facts. Maybe he didn't want to disclose before me that I and him, we had been working on the e-court for Lagos State just shortly before the pandemic started. And both of us would probably have been caught in England if we had traveled as scheduled by this pandemic. But thank God we eventually didn't go for one reason or the other. But we rose up to the occasion in Lagos State in view of the enormity of our caseload and the cry by the public that the justice sector cannot go to sleep, which we realize is also detrimental to security and business, and indeed general life in Lagos State and indeed the entire nation. So we were coming up with bits and pieces of directives on how courts can sit physically. But thereafter, we came up with these remote hearing directions. And the basic reason for that is from the awareness that some matters are time-bound, some matters have constitutional flavor, particularly criminal matters, where the liberty of citizens will be affected unless we find a way of hearing their cases. Basically, applications that will touch on remand, applications for bail, and probably delivery with respect to very serious offenses. And so we started toying with this idea. After some trial runs, we came out with the practice directions. And the aim is not to encapsulate all cases. We made it clear. I want to believe that we all have copies of the practice direction, please. The objectives are clearly stated there: timely and efficient disposal of cases, use of suitable technology and just dissemination of proceedings, and efficient use of available judicial and administrative resources. That last one is very key and probably has limited how far we have gone and how far we could go in the deployment of this method of hearing. We also provided for electronic filing of processes. Realizing how far we have gone, and I want to say that this area had engendered a lot of critique from learned colleagues, electronic filing of processes. We made an alternative that it could also be done at the court registry, knowing the state of technology and infrastructure we have on ground, not only as affecting the judiciary, but also as affecting lawyers and probably other stakeholders too, particularly citizens who may not be opportune to have the kind of technology to enable them do the filing electronically. But I can announce to you that as of Tuesday, electronic filing has started in Lagos. We have sorted out the little itch we had, and that has to do with the revelation of particulars by people who wanted to file processes. Until I satisfy myself that that's inescapable, particularly having talked to the tax authority about that, because complaints were coming from people who wanted to file processes. But I got words from the tax authorities that is something that is applicable all over the Federation now. You have to disclose your BVN in order to generate a PID, and then you can thereafter be paying seamlessly. But the long and short of it is that after we have satisfied ourselves on that, Lagos State has now begun electronic filing of processes. But one issue that still remains to be discussed there as to how we can solve it permanently is in situations where documents are very bulky. If you file electronically, yes, we will receive them here. What about the copies that are supposed to be simultaneously filed? Assuming you have a process of about 120 pages and you are meant to submit 12 copies, how do we receive the copies? I can say that as late as about 6:30 p.m. yesterday, I was in a meeting with my team at the High Court Ikeja here in trying to resolve that. And what we arrived at is that we may have to put in place a mechanism whereby we will have to do some bit of costing for the volume of the papers to be filed. That would be maybe per page or per folio, as they used to call it. And then that will have been, a regime will have been stated out for that. Everybody will know that if you're filing 120 pages, it is £1 per page extra to the original process. So that way, we will now put facilities in place at the High Court Registry here to make mass production of those documents after having been scanned when you are filing in the and so we can upgrade that problem. So that's much on e-filing, and then we'll improve on it as time goes by. Now, we have also said that the registry will receive documents for filing electronically, and that all documents to be filed must be scanned or converted to an appropriate PDF format and forwarded to the registry via the designated email address or WhatsApp. Well, we are stated in these practice directions that notices of hearing of remote hearings will be on the cost list of the courts and as well on the judiciary website. They will also be circulated and posted in appropriate places within the court premises, so that in that way you will have the widest publicity possible of such remote hearings. In the first place, they will be given special place on the court list, boldly marked remote hearings, causes involved will be listed, the costs involved will be listed, and then the particulars of the cases and the time schedule for them will be listed. And also this will be on the judiciary website, so that any party who is interested in any of the proceedings can log in through the website, and then will be allowed in by the administrator of the proceedings to participate, to watch the proceedings. And that's what we did, if you all remember, my dear brothers and sisters, on Monday when my brother Judge Dada J delivered a judgment in a criminal matter. I directed that the face of the judge should be seen, which eventually came up. And then all the parties involved were also seen. And also, so many people who are interested in watching the proceedings were able to participate. I was made to understand that we had almost over 100 people who watched the proceedings. I have directed that in order to give the proceedings such further publicity as much as possible, that will increase the capacity to allow many more people to participate by watching proceedings. That we are already doing by putting in the necessary infrastructure to allow that. So that's much for the publicity of the hearings. And that, I may say, will be in a way of addressing the criticism or observation raised by our LawNet colleagues as to whether remote hearings, public hearings. And if I may say straight away, our own take on that is that compared with the normal court situation, only parties and their counsel, and probably where necessary witnesses whenever they were to give evidence, will have been in the courtroom under normal circumstances. Nobody goes to invite anybody to come and watch proceedings. If you are interested, you simply come to the court. And if there is room in the court, you enter, you sit down, you watch proceedings. So likewise too, for virtual hearings, once we provide you with the particulars of what will allow you to be able to log in and watch the proceedings, once the judge sits in open court, and all other parties are logged on, and we can all see ourselves on screen. As for parties, I think the requirement of public hearing has been satisfied. And that again, to further ensure that is why I directed that we scale up it. And I don't know of any courtroom, at least in my own state, which can take 300 people watching proceedings at a time. So that this virtual hearing proceeding will even give better and more enhanced opportunities to the public to participate by watching proceedings. So I would think that Section 36 of the Constitution will have been so satisfied. And then I will go, and let me not forget that we provided that where it is impracticable to file processes electronically, the same may be filed at the registry of the court, so that we know the state of our technology and connectivity, and so not to leave anything out to electronically. Come and file them in the court premises. And I think that will plug in the gap. Now, the Chief Registrar shall designate appropriate officials who shall assess the fees payable by parties and communicate same to them by email, WhatsApp, or text message. We have decided to roll out a gazette of this scale of fees, and then if you want to pay electronically, I haven't had them, it will be seamless. You just pay electronically, and then you obtain your receipts electronically too. And we are also updated here on our site electronically, and then the life of the case can begin, or the application can begin seamlessly. Now, I won't like to waste time on assessment of payments and things like that, which I've just mentioned. The email address and contact telephone number of the registry, like I said, would have been made available on the Judicial Information System and the Judiciary website. Now, notwithstanding the provisions of the High Courts of Lagos State Civil Procedure Rules 2019, as well as the Comparative Magistrate Court Civil Procedure Rules, service of processes may be effected by email, WhatsApp, or as directed by the court. This is to allow for a situation where parties agree on another mode of service. Once they agree on it, and the court sees that to create any problem, the judge or magistrate may allow it. And that way, the issue of service is minimum. We also provided that service of processes shall be proved by filing an affidavit exhibiting a printout from the electronic device used in sending the process and showing the date and time of receipt of same by the other party. Well, after so much deliberation by the body of judges along with some of our senior magistrates, we also came up with that paragraph 13 there, where we said, where an electronic mode of service is employed, time shall prima facie, I will explain that, time shall prima facie begin to run from the day the process was sent. And we use the word prima facie there guardedly, so as to provide for situations where there might be disputes as to when processes were actually received. There may not be dispute as to when it's sent. The sender will know when he or she sent it. but the person receiving it may be the one to dispute. Oh, it was sent on Monday. No, I got it on Thursday. So that's why we use the word prima facie there. If such a dispute arises, then there can be further inquiry as
Hello?
We lost his lordship.
Yeah, so I can't hear my lord anymore, and but can you still hear me?
Yes, we can hear you. Maybe we've lost,
we can hear you.
lost the
Let's
CJ.
do it. I'm sure the signals will come back. I think it's probably likely to be a network problem.
Yeah.
The same network, eh?
So I think it appears we've lost my lord right now because he's gone off the screen completely.
He's back on. He's back.
On. All right.
His microphone is muted.
Okay. My lord, I think your mic is muted. If you can please unmute. Thank you very much, sir.
Thank you. Can you hear me now?
Yes, sir.
Yes, very clear.
We can hear you.
Sorry, and that's please, you may note that as well. There's a loss of connectivity as to its consequence. Gentlemen and ladies, there will discuss later. Maybe that was a practical demonstration of what will happen.
Absolutely.
Now, remote hearings we said here shall be by Zoom, which we are using now, Skype for business, or any other video communication method. And there's something that the court could provide. We will go ahead with you in ensuring that the hearings are conducted timelessly too. Now, we said that before the court orders a remote hearing, the registry will liaise with all counsel on record to ensure that suitable facilities are available. The court shall thereafter direct an appropriate remote communication method for the hearing, or where impossible or not agreed, an adjournment of the case if a remote hearing is not possible. And the notice of the remote hearing shall also be stated on the court list and the judiciary website, as I earlier said, and shall be communicated to counsel and or parties by email, WhatsApp, or any other electronic means as the court may direct. Now, so the conduct of the proceedings in the court shall give directions to parties during remote hearings on the use of video and audio during proceedings. This is targeted at ensuring that the official record, the authentic record of proceedings, will be one made by the court. No party will be allowed to do personal recording, either audio or video. And in any case, because of the state of technology, we know that some may still be able to breach this. What we are saying there is that in any case, and at the end of the day, it is the record of the court that will be the authentic record of proceedings. Of course, where, as you lawyers used to do, where you want to dispute records of the court, you know the proper procedure to take. Like I said earlier, Shashore, you are laughing at that. Like I said,
No, I don't.
you can take the necessary procedure to do that. So that opportunity is not taken away from you. So there cannot be any complaint about the denial of fair hearing on that. Now the counsel, hello, I guess I'm still with you. I guess I'm still with you.
Yes,
Yeah,
sir.
we can hear you.
Thank you very much.
We can hear you, my lord.
And we also provided that counsel shall dress appropriately and parties shall be properly dressed for court proceedings. You will know that we had provided earlier that the judge or magistrate will sit in open court. We had come to that conclusion because of the plethora of judicial pronouncement by this apex court on what is a public hearing or a court hearing. So in order to obviate any unnecessary criticism on that as to affect the validity of proceedings, we have intimated that every judge or magistrate will sit in open court for the proceedings. So if a judge is robed, I guess it follows that the lawyer too must be robed. It equally follows that as in the ordinary courts, physical courts, parties too will dress properly. So the several observations raised as to improper dressing, these rules, these practice directions are duly taken care of. So we may not have any problem with that. Now, we also provided for recording. I think I had mentioned that recording of proceedings by counsel and of parties shall only be with the leave of court. And then at the end of proceedings, certified copies of proceedings shall be made available upon request, as is the case in the normal physical court sittings. Now we came to adoption of written addresses. And adoption of written addresses we provided shall be in compliance with the provisions of the rules of court. You move your application, you will have already filed your written addresses along, and then you just move your application, you adopt your addresses. The opportunity to do oral adumbration is still there. But if parties agree, and maybe because of availability of time on this kind of proceedings, now we also provided that oral argument of such written briefs may be dispensed with if parties agree, so that nobody will complain of having been shortchanged, just like what was done to Tayo earlier on in these proceedings. Now, notice of delivery of judgments or ruling provides that the court shall, through the registry, notify counsel and or parties by email or WhatsApp of the date reserved for the delivery of judgments or rulings. And that's in a case where the judge or magistrate did not deliver his ruling or judgment right there on the bench. Normally, you'll be notified of the dates. And all dates, when remote hearings shall come up, and for whatever proceedings, all will still be put on the cost list and on the judiciary website, as I earlier stated, so that from the beginning of the matter up to the conclusion of that matter, all the parties, queer counsel, parties or witnesses, and every other person who is interested in watching those proceedings will have notice from the beginning to the end. That's how much we have said. But let me now, outside the provisions of the directions, react to some criticisms. These rules were like emergency rules made for emergency situations. But it has become clear to us that this is the way to go. And like I said, I and the Attorney General have been fervently working on our e-court in Lagos State. And this just came in now to tell us that we may need to fast track that, and we certainly will do so. And as to hearing of cases in full, issues have been raised as to cross-examination, tendering of documents, and other proceedings like that. My own take is that as for cross-examination, there should be no difficulty at all. I will also mention management of documents, which will normally feature in trials. But let me take cross-examination first. We are all seeing ourselves there. Once the parties are seen, all the counsel are seen from their different locations. Now, I don't see any difficulty in counsel cross-examining witness, or in counsel raising objections, or delivering addresses in respect of the proceedings. What could arise and which might be problematic is the issue of tendering documents. Tendering documents and probably objections to documents. Tayo, let me say, because I don't want you to sue me for plagiarism. When we discussed, you told me that for your arbitration proceedings, You have a provision like the manager of documents. For the high courts or the courts, we will have had case management conferences. Using this methodology of hearing now makes that particular stage of proceedings much more important and much more critical to be properly utilized. At case management conference, parties could settle on which documents they are not objecting to. Those are taken apart. Those are marked down by the courts, not necessarily as exhibits, but they are given a nomenclature, maybe 1, 2, 3, all the documents we now know. Deed of assignment 1992 is exhibit number 1, document number 1. So that when you come to trial, those that are not objected to are taken in seamlessly. Those that are objected to will also have been dealt with as CMC. At that point in time, and we will look back into our rules of court to see whether this is allowed as the rules are presently couched, or we need to tinker with the rules maybe by way of further practice directions. Those objected to, both counsel can argue on them, the judge can write his ruling on them, and then they are resolved one way or the other. But what I see in that again, as something that may come up, is that as usual, lawyers where they don't agree with such rulings will say they want to appeal, and then they want stay of proceedings. These are things you erudite persons there will discuss. But as the judge, we will listen to you, and then we can, on both sides, chart the way forward. Now, we also intend to do something like you have been doing in arbitral and other non-formal court proceedings with respect to management of documents, so that when it comes to the real trial, we'll be able to get over this as seamless as possible. The other issue, I think I will stop at that for now, and probably may react to issues raised later. Thank you very much.
My Lord, the Honorable Chief Judge, thank you very much. You raised a number of issues which indeed some of our panelists today are going to be addressed. And in fact, on the chat facility of this platform, I have seen some questions being put across that anticipate some of the questions you have raised. So my Lord, thank you very much. I'm sure you'll get the opportunity to respond further to those questions.
Thank you
very much, my Lord. So at this point, I will give the floor to Honorable Justice Oshodi, who is going to be exploring the question, restoring full services in justice delivery, scaling up the use of virtual hearings. My Lord, Honorable Justice Oshodi, the floor is yours.
I'm sure we can now hear me. Hello?
Yes.
Yes,
yes, we can hear you, my Lord. We can
Yes,
hear
my
you.
Lord. Yes, my Lord.
Good afternoon. Good afternoon, my Lord, the Honorable Chief Judge, ladies and lords here present. The Honorable Attorney General, NSLs, Your Honors, members of the bar, the participants, and all stakeholders here present, ladies and gentlemen. The topic highlighted for me to discuss is restoring full service in justice delivery, scaling up the use of virtual hearing. I must confess that the word restoring used in the context of virtual hearing in justice delivery in Nigeria is a bit misleading. This would suggest that there had earlier been virtual hearing judicial proceedings before today. This is not. As it is well aware, Lagos State Judiciary has an information system named Judicial Information System, GIS. This system came online on 2nd October 2013. As from that date, any case filed at the Higher Court is captured in this system through e-filing, pursuant to the practice direction issued by the Honorable Chief Judge then, Honorable Justice Phillips. In that year, October to December 2013, a total of 1512 cases were filed by way of e-filing, and for subsequent years till date, I beg you, I need to give you the stats for a reason. 2014, 6,445 cases, 2015, 7,080 cases, 2016, 8,046 cases, 2017, 8,708 cases, 2018, 8,318, 2019, 7,800, 2020, till date, 2005 cases. From the stats provided above, it can be seen that an average of 8,000 cases are filed in a year, which has to be distributed to about 60 honorable judges sitting within Lagos State Judiciary. This roughly comes to about 134 cases per each judge per year. Now, with the outbreak of this pandemic, COVID-19, the court has been under lockdown and nothing substantial had been done. There's been a lot of debate whether the court ought to conduct proceedings virtually, and various comparisons have been made with different jurisdictions abroad. While this is a nice concept, we must have in mind the peculiarities of our own setting, that is, the law upon which the courts draw up their judicial powers. The crucial law here is the provision of Section 33 of the Constitution as amended. This section deals with the right to fair hearing. I am sure we all participating today will appreciate the importance of the right to fair hearing in our justice delivery. In Baba versus NCATC, citation 1991, 5 Endobera, part 192, page 388, the Apex Court held that for an hearing to be fair, it must include the right of the person to be affected, 1, to be present all through the proceedings and hear the evidence against him, 2, to cross-examine or otherwise confront or contradict all witnesses that testify against him, 3, to have read before him all documents tendered in evidence. My Lord the CJ, please, if you can mute your speaker, sir. If you can mute your speaker, sir. 3, to have read before him all the documents tendered in evidence at hearing. 4, to have disclosed to him the nature of all relevant material evidence, including documentary and real evidence prejudicial to the parties save in recognized exceptions. 5, to know the case he has to meet at the hearing and have adequate opportunity to prepare for his defense, and to give evidence by himself, call witness if he likes, and make oral submissions. Then Section 36(3) of the section provides as follows: the proceedings of a court or proceedings of any tribunal relating to the matters mentioned in subsection 1 of this section, including the announcement of the decisions of the court or tribunal, shall be held in public. There are many decisions of the Apex Court on this latter provision of the Constitution, notably Misiru, Alimi and others versus Asani, Koshebinu and others, 2016, LPELR 42557, Supreme Court. Now, it is not my duty to critique this position of the law vis-a-vis virtual hearing, as I can see that both Messrs. Shukwashashore SCN and my Naya SCN will do the honors later. I have checked but cannot find the meaning of virtual hearing in all the websites I visited. However, virtual hearing can be described as a hearing done remotely with the aid of technology, whereby participants can state their respective case in their remote locations without physically being within the courtroom. That is, hearings conducted online, real time. Now, is it feasible for courts to use virtual hearing for some of these proceedings? My answer to that is a yes, but our rules of court ought to be amended to include provisions that will enable the court to so do. For example, a look at Part 5 of the Civil Procedure Rules of the United Kingdom, which deals with court documents and electronic mechanical signatures, may be helpful. I am aware that the President's direction can also cure this, which the Honorable Chief Judge had issued and is enforced as a date. In truth, hearing proceedings virtually is not a feat that cannot be overcome. The minimal infrastructure to enable such hearing are in place and not necessarily an add-on, which will incur further costs. The internet connectivity is good, at least in Lagos, and there are smartphones available for most of us. Most of us have the smartphones which are internet enabled. We are all aware of the Zoom. We are all aware of Zoom, Skype Business, Google Meet, GoToMeeting, Microsoft Teams, and various other applications in store. In reality, and in my view, taking into consideration our jurisprudence, the cases that will be appropriate for hearing virtually ought to be cases bordering on fundamental human rights, cases commenced by way of applications where affidavit evidence is the source of evidence and applications for bail, where the presence of the defendants can be dispensed with. From the stats mentioned above, the total suits which are by way of application filed this year is 343. I am very sure that if these applications were taken or added virtually, over 80% would have been dispensed with by now. In this respect, once all the processes have been filed and the Honorable Judge is ready to take it, counsels who must have endorsed their contacts on the processes filed by them will be notified electronically of the virtual hearing. It is suggested that this notice also be posted on the judiciary website and cause list for the attention of the public. Once counsels have been notified, the virtual hearing can be conducted and, if possible, a ruling judgment delivered on the same day, since the documents to be considered are before the courts. With this scenario, the Honorable Judge will only see counsels on such matters through video, and a lot of time will be saved by all concerned. This is also comply with the social distancing policy. The practice direction as issued by the Honorable Chief Judge will take care and has taken care of all the preliminaries from filing to hearing. It is robust enough. However, for trials in criminal matters or trials in civil matters, where the demeanor of witnesses is key, especially during cross-examination, it is my view that virtual hearing will not be appropriate and may constitute a breach of the principle of fair hearing as brought up before. I should also add at this point that as a date, the Controller General of the Correctional Facilities has directed that no inmate is brought to court for now. In this instance, I would suggest that rulings and judgments may be delivered through virtual hearing in criminal matters, with the defendant being present remotely at the correctional facility. I do not think this will constitute a breach of fair hearing for a defendant in custody. But for the defendant on bail, his presence physically in court cannot be excused. Going on, the use of virtual hearing may limit the legal representatives' interactions with their own clients, who, for example, cannot easily pass notes forward or have a quick discussion during trial. These micro-interactions shape the social dimensions of our justice system, and it is not easy to replicate this via virtual hearing. The only exception here is where a witness is not within jurisdiction, and to save time and cost, upon an application of either counsel, such witness may give his or her evidence virtually. The advantage here is that legal practitioners will be able to read the judge's reaction and act accordingly, which is key in any hearing and proceedings by video link. In addition, it is possible for the hearing to be recorded and also made available to the public. The added advantage is that for those legal practitioners who are also participating as observers on mute and with no video, being on one's laptop means efficient access to all the documents that may not ordinarily be the case if they had attended the court with only key documents in hand. Given the uncertainty with the current situation, it is clear that virtual hearing is the way forward in order to allow for the administration of justice to continue. There are significant cost savings for all parties involved, including moving forward in relation to the preparation of electronic bundles over hard copy bundles. For virtual hearing, there is greater flexibility of process, no travel time, or costs associated with attending a distant court. It is arguably less intimidating and possibly more comfortable for participants as they dial in from their own home or offices. In concluding, I will say without fear that Lagos State Judiciary is ready to conduct hearing virtually if given the green light by the relevant authority and support from learned councils, including the seniors. Still, care must be taken in relation to how technology is incorporated into the existing justice system to ensure that people do not feel as confident using it, to ensure that the people who do not feel as confident using it are not left behind. Lastly, may I direct our attention to the principle of salus populi suprema lex esto, which translated means the health, welfare, good, salvation, felicity of the people should be the supreme law. Let the good or safety of the people be the supreme or highest law, or the welfare of the people shall be supreme law. Is a maxim or principle found in Sirius, the legal books. The benefits of virtual hearing is all for us. Thank you very much.
Thank you very much, my Lord, the Honorable Justice Oshodi. That was a very enlightening presentation. It raised questions, a good number of them constitutional, and I'm very happy that we have a constitutional panel here today that will be able to take those points that you have raised in their presentations. Before we move on to the panelists who will dissect some of the questions, evidential, constitutional, and even some more questions that we have been receiving on the chat facility of this platform, I will hand over the floor to two gentlemen, Dan Wilmot of Stewards and Joe Al-Kayat, the founder of Resolve Disputes Online. We are very much behind time, so gentlemen, Dan and Joe, I would urge, if it's possible, for you to keep your presentations within 10 minutes each. I know that's you know, springing that on you at this time is terribly unfair, but please, just to help us catch up with time. So if you can both explore the subjects that we are going to be talking about: e-filing, e-service, video conferencing, document management, recording and transcribing, it will help to answer some of the questions that we've been receiving on the chat group. Thank you very much. So I'll give you the floor, Dan.